Welcome to An Ounce of Prevention, a podcast from Skadden's White Collar Defense and Investigations Group.
Hi, and welcome to An Ounce of Prevention, a new podcast series presented by the White Collar Defense and Investigations team at Skadden. This podcast will bring you regular analysis of key compliance and white-collar crime trends, important industry news and developments, as well as insights from the leading practitioners in the field. My name is Andrew Good, and I'm a partner here in Skadden's London team. I specialize in representing clients in complex governmental and regulatory investigations into fraud and other misconduct, for example, bribery, false accounting, money laundering, and other related offenses. The topic for our first episode today is the new UK failure to prevent fraud offense, which will come into force on the 1st of September of this year. We'll be discussing this new offense and what companies can do to prepare for this change. And to talk about this new offense, I'm joined today by my colleagues Jonathan Benson and Jason Williamson. Jonathan's a counsel in our team here in London who has spent almost a decade counseling companies on a range of business compliance issues and who, prior to joining Skadden, worked as a senior lawyer within the UK government. Jason is a European counsel specializing in cross-border investigations into allegations of corporate misconduct, including fraud, bribery, corruption, and money laundering. Welcome to the Ounce of Prevention, guys.
Thank you.
Thanks, Andrew. Great to be here.
So, Jonathan, this isn't the first failure to prevent offense in the UK. We already have a few of those. Why is this one different, and why is it significant?
Yeah, you're absolutely right, Andrew. In a sense, this is just another failure to prevent offence, similar to the failure to prevent bribery offence under the Bribery Act of 2010 and the failure to prevent the facilitation of tax evasion under the Criminal Finances Act 2017. But I think that this is a very important legal development, and where this new offence is different is that it applies the same principle of expanded corporate criminal liability to fraud, the most widespread of economic crimes in the UK, and actually one of the most frequently committed crimes in general. So the new offence will make it easier for companies to be criminally prosecuted for failing to prevent fraud in their operations, and they need to pay attention as a consequence.
We'll get into how companies can address and mitigate that risk in a moment. First, I think it's important to talk a little bit about where this new offense came from.
Yeah, so under the previous government, there was a lot of talk about bringing forward new economic crime legislation and really to make it easier to hold companies accountable for criminal misconduct. That ultimately led to two new economic crime bills, one in 2022 and one in 2023. And the failure to prevent offence sits within the 2023 Act. And that is called the Economic Crime and Corporate Transparency Act. And the 2023 Act, it made a number of changes beyond the failure to prevent offence that were designed to make it easier to combat economic crime. So it introduced new powers for Companies House and the Serious Fraud Office. It also extended law enforcement powers under the Proceeds of Crime Act, including in relation to cryptocurrencies. And perhaps most importantly, alongside the failure to prevent offence, is that it made changes to the identification principle, which made it easier for companies to be held accountable for a wider range of economic crimes.
I think that last point is worth pausing on for a moment. Before the 2023 changes, corporates could only be prosecuted for certain economic crimes in the UK if the prosecution could show that someone acting as the directing mind and will of the company had the culpable state of mind for the offense. This makes it difficult in practice, or it made it difficult in practice, to successfully prosecute companies, particularly large businesses with a complex management system. The 2023 Act changed this so that a company can be held liable for certain economic crime offenses, for example, bribery, tax offenses, money laundering, fraud, and false accounting, if the offense is committed by a senior manager. And senior manager is defined broadly and will likely cover persons in the direct chain of management, and those who are in strategic or compliance roles. This is therefore a significant change that has the potential to make it much easier for UK law enforcement authorities to prosecute corporates for economic crime.
Precisely, Andrew. It's also worth noting that the previous government put forward a proposal in the Criminal Justice Bill of 2023 to extend this new way of attributing criminal liability to companies so that it would apply to all criminal offences and not just certain economic crimes, as is currently the case. That change has now been adopted as part of the new Labour government's Crime and Policing Bill, which was introduced into Parliament in February of this year. Given that criminal justice reform was a key part of the Labour government's manifesto, and in light of their parliamentary majority, it's very likely that this further change that's proposed to the law will come into force relatively soon.
So we haven't heard the last word on the expansion of corporate criminal liability, I think, have we?
I think that's just about right.
All right. We've covered some of the background on this new offense, but maybe Jason, could you tell us a little bit more about what types of conduct the offense covers?
Sure. So broadly speaking, there are two elements to the offense. The first is that an associated person of a company must commit one of the fraud offences that are listed in the 2023 Act. And the second is, at the time of committing the offence, the associated person must have intended for the fraud to either benefit the company or another person who received services from the associated person on behalf of the company. And the fraud offences that are listed in the 2023 Act, the fraud offences listed in the 2023 Act are wide-ranging and include offences under the Fraud Act, so fraud by false representation, failing to disclose information, and abuse of position. It also includes the false accounting offences, the fraudulent trading offences, and cheating the public revenue, or to put it simply, tax-related fraud. So the scope of the offence is incredibly broad, and it could cover a whole range of potential misconduct. It could cover false representation and warranties made in transaction documents and other disclosures. It could cover fraudulent misreps in company accounts or misreps about the quality of goods and services, and so on.
So if an associated person of a company commits any of these listed offenses, the company itself is then criminally liable for failing to prevent that fraud?
Exactly. So the company will be held liable under the offence on a strict liability basis, but the legislation does include a couple of potential defences. So the company will have a defence if it can show it had reasonable fraud prevention procedures in place at the time the offence was committed, or that it was reasonable to not have those procedures. And the company itself will also not be prosecuted if it was a victim of the fraud.
Okay. Well, it seems like it's going to be very important for companies to ensure that they have the right procedures given that strict liability regime. Let's come back to this defense in a second, but I wanted to first drill down a bit on the key elements of the new offense. Does the phrase associated person here just mean employee?
No, not quite. The definition of associated person is broadly similar to what we're familiar with under the Bribery Act. So it includes, for example, employees, but also agents and subsidiaries of the company, or anyone else who performs services for or on behalf of the company. Whether the person is an associated person will, of course, depend on the specific facts. The government has clarified that franchisees or suppliers will not be associated persons just by virtue of being a franchisee or supplier. They would have to provide services for or on behalf of the company to fall within scope.
Okay, and does this apply to any company in the UK?
No, it only applies to so-called large organisations, and the legislation specifically exempts small and medium-sized enterprises. So a company will be deemed to be a large organisation under the Act if two or more of the following conditions are satisfied. Firstly, it has more than 250 employees. Secondly, its annual turnover is more than £36 million. And or thirdly, its balance sheet assets exceed £18 million. And a parent company of a corporate group will fall within the scope of the new offence if similar criteria are met on an aggregate basis. So coming back to your question, Andrew, it's not just UK large organisations. A company does not have to be incorporated or registered in the UK to potentially be liable. The Act applies to an entity wherever formed or incorporated.
So can you talk to me a little bit about the extraterritorial nature of this? I mean, is this something that's going to apply to activity happening outside of the UK?
So I think that very question, Andrew, is the thing that's generated most discussion since the government introduced this new offence. And the territorial scope of the offence is not straightforward. It relies on the underlying fraud offence and the territorial reach of that. So generally speaking, to prove that a fraud offence has been committed under English law, an element of the offence must take place within the UK or have UK victims. So putting that into context, you could have a situation where an employee of an overseas company commits a fraud, and the only UK touch point is that that fraud has UK victims. According to the UK government guidance as it currently stands, that could be enough to bring the company within the scope of the failure to prevent fraud offence.
Okay. That'll be interesting to see how that plays out. Under the new offense, though, there is this affirmative defense. Does that mean a company is able to avoid guilt under the new offense if they have fraud policies in place?
So the 2023 Act states that a company will avoid criminal liability provided it can prove that it had, quote, reasonable fraud prevention procedures in place at the time of the alleged fraud, or that it was reasonable not to have such procedures in place. Therefore, the focus will be very much on those policies and procedures, because for most companies, it will be pretty difficult for them to say that it was reasonable for them to not have any procedures. The legislation doesn't specify what reasonable fraud prevention procedures are, but the government has published guidance on the topic. Broadly, according to this guidance, companies should follow 6 principles when designing their policies. And these 6 principles will be ones that people will be familiar with to some degree, and no doubt will also be what they would expect, because they track similar guidance issued in connection with the other failure to prevent offences. So we're talking about top-level commitment, risk assessment, proportionate risk-based prevention procedures, due diligence, communication training, and lastly, monitoring and review. Companies should make sure that senior management are involved in designing and communicating the policies, that there's a culture of preventing fraud that permeates from the top, that the risks of fraud within the organisation are identified and addressed in a proportionate way, and that there are due diligence procedures in relation to the relevant associated persons.
And if a company hasn't got these policies and procedures set up in time and something is identified after September of this year, what happens?
Well, there is, of course, the risk of prosecution. In terms of penalties, the penalty for this offence is a fine. But as people will be familiar with from the Bribery Act context, fines in this area can be very large indeed. The legislation also adds the new offence to the list of crimes for which a deferred prosecution agreement is available.
What should companies be doing now to prepare for the new offence coming into force?
So as Jonathan touched on, I think having the right policies and procedures in place is going to be critical. If a company comes under law enforcement scrutiny because a fraud has been committed, it will be important for it to be able to demonstrate that it had the controls in place to prevent that fraud. And as Jonathan said, that showing that it was reasonable to not have those procedures is likely to be quite difficult. So the government has issued guidance, and that provides a high-level overview of what law enforcement expect to see in those policies and procedures. And that guidance has recently been supplemented by industry guidance published by UK Finance for financial services companies. And although that guidance is useful, the exact controls that a company implements will depend on a range of factors. So, the size of the organization, where a company does business, where it has third-party relationships, and the particular risks within its operations. And as we often see with other ABC compliance policies, what is proportionate and reasonable will really vary between organizations. And that will largely depend on the output of a company's risk assessment. So as you mentioned, Andrew, at the beginning, the offence does not come into force until the 1st of September. So this does give companies time to review existing anti-fraud procedures, update risk assessments and compliance training programs, and to really consider whether any new controls or policies are required.
Well, it sounds like this is a pretty big change coming down the pipeline for companies, and there's a lot for them to think about as they prepare for this offense coming into force. Jonathan and Jason, I wanted to thank you guys for coming on and helping us understand this important development. Appreciate it.
Thank you very much, Andrew.
Yeah, thanks, Andrew.
And that's it for the premiere episode of the Ounce of Prevention podcast. We hope you can join us next time, but in the meantime, stay vigilant, stay compliant, and join us for the next episode of the Ounce of Prevention, where we'll be discussing another key topic shaping our industry. Till then, goodbye.
Thank you for joining us for today's episode of An Ounce of Prevention. If you like what you're hearing, be sure to subscribe in your favorite podcast app so you don't miss any future conversations. Additional information about Skadden can be found at skadden.com.